I'm Rosma. Welcome to video 2, Legal Environment. The human resource management field is greatly influenced by state and federal employment legislation. In actual fact, regulations and laws govern all aspects of human resource management, including recruitment, development, compensation, and safety areas. In this video, we will discuss about the important acts related to human resource management in Malaysia. By the end of this video, you should be able to identify legal acts that influence human resource management, explain the aspects in each act that influence human resource management, and discuss the purpose of each work-related act enacted by the Malaysian government. Are you ready to learn about important acts related to human resource management in Malaysia? Great! Let's begin with this chart. The chart shows the most important acts related to human resource management in Malaysia. They are the Employment Act 1955, Industrial Relations Act 1967, Trade Unions Act 1959, and Occupational Safety and Health Act 1994. Other important acts related to human resource management include the Employee Social Security Act 1969, Human Resource Development Act 1992, Employee Provident Fund Act 1991, and Workmen's Compensation Act 1952. Let's discuss further on these acts. The first act is the Employment Act 1955. The Employment Act 1955 was enacted with the purpose of protecting employees from being exploited by employers and became the legal foundation in highlighting the minimum conditions and terms related to work that need to be followed by management. This act protects employees who are contractually bound to the management and their monthly salary is not over 1,500 ringgit Malaysia per month, or not taking into account their monthly fees and work as a manual laborer or supervisor of manual laborers or person involved in handling motor vehicles or domestic employee. A new section, Section 69B of the Act, provides protection for employees whose wages are more than 1,500 ringgit Malaysia per month, but do not exceed 15,000 ringgit Malaysia. The Director General of Labour is now empowered to hear complaints under Section 69(1)(a) from this category of employees. However, Section 69B(3) stipulates that the rest of the provision of the Act do not apply to them. The Employment Act 1955 protects not only full-time regular employees, but also part-timers, temporary or fixed-term contract employees. This Act sets out the minimum conditions of employment, which include A written contract of service which states the terms and conditions, including the notice period required to terminate it. B. Payment of wages that must be paid not later than the 7th day after the last day of any wage period. C. Recruitment of female employees in any industrial or agricultural undertakings between the hours of 10 o'clock in the evening and 5 o'clock in the morning, unless with the prior approval of the Director General of the Labour Department. D. Payment of maternity allowance for female employees on maternity leave for 60 days at the ordinary rate of pay subject to a minimum rate of 6 ringgit Malaysia per day. E. Normal hours of work shall not exceed 8 hours a day or 48 hours a week. And F. Leaves which include 1. 10 paid public holidays plus any ad hoc public holidays declared by federal government in any one calendar year. 2. 8 days of paid annual leave for employees with less than 2 years of service. 12 days of paid annual leave for those with 2 or more years of service but less than 5 years of service, and 16 days for those with over 5 years service. And 3. 14 to 22 days sick leave in a year depending on length of service and where hospitalization is necessary, up to an aggregate of 60 days sick leave in each year. Now, how many days of annual leave or sick leave are you entitled to? The second act is the Industrial Relations Act 1967. The Industrial Relations Act 1967 is an act that emphasizes on employer-employee relations and their trade union. It is also intended to prevent and avoid any differences or disputes that arise from this relationship, as well as to deal with any trade disputes and related matters. Among the aspects covered in the Act include 1. Protection for all parties. 2. Recognition and trade union scope. And 3. Collective bargaining and agreements. The third Act is the Trade Unions Act 1959. Bounded under the category of employment relations, this Act governs the registration of a trade union. Any newly formed trade unions are required to apply for registration within a month of their formation. This Act also covers the membership criteria and the rights, power, and responsibilities of a trade union and its managerial prerogatives for any collective bargaining. The purposes of Trade Unions Act 1959 include to A. Encourage industrial relations, amend work terms, social and economic status, and increase productivity. B. Outline the relationship between employees and employers. C. Represent employees or employers in any trade issue. D. Manage items related to industrial issues. And E. Plan and support any actions such as industrial strike. The fourth Act is the Occupational Safety and Health Act 1994. The objectives of this Act are A. To ensure the safety, health, and welfare of employees at the workplace. B. Protect others that are present at the workplace from any accidents that may be triggered from workers' activities. C. Ensure the work environment is conducive. And D. Enable related legalities be replaced in stages by industrial rules and regulations which are approved and practiced by all in order to maintain and increase the standard of safety and health at the workplace. This Act was enforced throughout Malaysia for all industries except the armed forces and shipping-related employments which are protected under the Merchant Shipping Ordinance 1952 and Merchant Shipping Ordinance 1960 for Sabah and Sarawak. Now, let's move on to the fifth Act, which is the Employees Social Security Act 1969. The Social Security Organization is an organization set up to administer, enforce, and implement the Employees Social Security Act 1969 and the Employees' Social Security General Regulations 1971. What does SOCSO stand for? SOCSO is short for Social Security Organization, or commonly known in the Malay term as PERKESO or Pertubuhan Keselamatan Sosial. The Social Security scheme aims to protect employees from any unexpected occurrences such as disasters at work, accidents, and death. This scheme ensures benefits payment to employees and their dependents through various protection schemes. The sixth Act is the Human Resource Development Act 1992. This Act aims to increase employee training by imposing and collecting human resource development levies. Apart from establishing human resource development councils and human resource development funds for this purpose. The seventh Act is the Employee Provident Fund Act 1991. The Employee Provident Fund Act 1991 aims to encourage employee savings for the purpose of retirement. This act is also known as Kumpulan Wang Simpanan Pekerja (KWSP). KWSP is a government organization in charge of social security or retirement planning for legally employed workers in Malaysia. All employers must register their employees with the Employees Provident Fund immediately upon employment. The final act is the Workmen's Compensation Act 1952. This act is administered by the Department of Labour and applies throughout Malaysia. It aims to compensate employees who are injured or contracted illnesses caused by their work. This act provides for the compensation payment to an injured employee or worker arising out and in the course of employment or contracting occupational disease. Where the employee dies in the event of fatal accident or contracting an occupational disease or in the course and arising out of performing his duty or work, this act provides for the compensation payment to the worker's dependents. Before I end this video, I will leave you with this question. Who are covered under the Workmen's Compensation Act 1952? In this video, we have discussed the important acts related to human resource management in Malaysia. They are Employment Act 1955, Industrial Relations Act 1967, Trade Unions Act 1959, Occupational Safety and Health Act 1994, Employee Social Security Act 1969, Human Resource Development Act 1992, Employee Provident Fund Act 1991, and Workmen's Compensation Act 1952. We hope you find this video helpful and we look forward to see you again in video 3. All the best and keep learning!